If I have a transvaginal mesh case, will my case go to trial?
Well, unlike the Christine Scott case, which did go to trial in California, very, very few cases will be tried. Out of the tens of thousands of transvaginal mesh cases, about 5 cases will be chosen for trials. And those cases may or may not be tried. But if they are, they'll be tried in West Virginia, in the federal court there. And the likelihood that you're going to be one of those cases is about 1 in 20,000 or so. But the trial is not necessary for you to get the advantage of the MDL trials, because what happens is this: the huge advantage to the MDL for an individual plaintiff is 2 things. Number one, you cannot possibly afford to prosecute a case, a single case of your own, against the big manufacturers. They're spending millions and millions and millions of dollars to defend these cases. They have teams of untold numbers of lawyers who are reviewing millions of pages of documents right now to defend these cases. And for you to try to go to trial against them in a one single case, it would cost you more to prosecute the case than the amount of your recovery. So what happens is, when you join together with thousands and thousands of other people, then at the end of the case, the judge says, okay, 1% of your recovery or 2% of your recovery, whatever the judge decides, will be taken out to go to pay those common expenses. So a 1% of the recovery is a very nominal sum to pay to sue a large manufacturer. So that helps you considerably to prosecute your case. And you get the advantage, all the people putting together all their money and all their expenses and all their lawyers and putting it together into a plaintiff steering committee and doing all the work and reviewing all these millions of pages of documents, hiring and retaining and preparing experts and presenting experts. All that is paid for cooperatively by all the plaintiffs, but you get the advantage of every single bit of it in your individual case. The plaintiff steering committee is in the business of establishing liability on each of the defendants, on each of the devices, regardless of when they were revised, when the new warnings came out. That's why this is so complicated. But that's the job of the plaintiff steering committee, is to establish that liability. Now, here's the second big advantage to you in an MDL. We will handle your case in the MDL, but when it comes time to talk about settling your case, to mediate your case, we will prepare your case individually, we will negotiate it individually, and we'll settle it individually. Even though we have thousands of clients, the thousands of clients is a huge benefit to you, because there is definitely strength in numbers. So the more cases I have, the stronger docket I have, the more credibility I have, and the more the defense bar has to deal with me and with your case. So in the mediation process, we will review your case, we'll get your medical records, we'll prepare your case individually, we'll have it reviewed by a medical team. We will then negotiate it, and we'll settle it. If it doesn't settle, then if we don't get settled in the MDL, which is most unlikely because the whole purpose of the MDL is to resolve these cases, but if it doesn't get settled in the MDL, we'll come back and we'll try your case. We're perfectly capable of trying these cases. We've been doing it for years with considerable success.